Welcome to the S&C Critical Insights podcast, and thank you for listening. I'm Garrard Beeney, co-head of Sullivan and Cromwell's Intellectual Property Law Group. Today's topic is filled with acronyms, SSOs, SEPs, FRAND, RAND, and a bunch of other things. It's really a topic that is of significance to IP practitioners really around the world, and I'll get into what those acronyms mean in just a second. But today's topic is really what's a fair and reasonable royalty in a patent that's essential to a standard, and can you obtain an injunction on the use of that patent claim if you have promised to license your patents under fair, reasonable, and non-discriminatory terms. So what do all these acronyms mean? First of all, SSO stands for Standard Setting Organization. These have proliferated over the last decades and now impact our lives in all sorts of ways, all the way from the typical controls for refrigerators to the way our phones connect with base stations. SEPs, what's that? It's a standard essential patent, typically a patent that reads on the standard that has been developed by the standard setting organization. FRAND or RAND is something that means fair, reasonable, and non-discriminatory licensing. As I'll explain in a minute, it's a promise that SEP owners give to SSOs about patents that may impact standards that are set by the standard setting organizations. Let me start with just a little bit of background. From an antitrust point of view, SSOs, those that set standards and include industry participants, are basically horizontal competitors determining a product specification. It can be looked at in some ways as an agreement not to compete. But a standard setting organization is also pro-competitive in many ways. It allows consumers to choose any class of products without worrying whether they have to comply with a particular interconnectivity or other standard. Example is the standard that was set many decades ago for plugging lamps into an outlet, a two-prong outlet used in the United States. So consumers going out to buy lamps can decide whether they want to buy any lamp without worrying whether it's going to plug in. Same is true with any other standard that's set. For some of the examples I'll be using today for phones or handsets, there are interconnectivity standards that have been developed by a variety of different standard setting organizations so that a consumer can go out and buy any phone and all those phones can compete without a consumer generally having to worry about whether a phone would necessarily connect with its carrier's base station. One problem that arose historically in standard setting organizations was that participants would advocate for a particular technology, have that technology adopted into a standard, and then ultimately, after that standard was adopted and implemented through a series of capital expenditures by implementers, then disclose that they had a patent on that standard. Obviously, with the capital investment that's made in the standard implementation, the patent owner had leverage in any kind of license negotiation. The implementer had to implement the standard and therefore had to use the patent, and so this patent owner came to the negotiations for a license with significant market power. The standard setting organizations originally tried to deal with that issue by requiring patent disclosures, requiring those that participated in standard setting organizations to disclose that they had patents on the particular technology that they were advocating for adoption into the standard. But that proved to be not terribly effective, and even though the Federal Trade Commission several decades ago brought a number of cases arguing that the failure to disclose patents constituted an unfair act of competition, the standard setting organizations moved over the last several decades to implement something called FRAND policies. That is, requiring those who participate in standard setting organizations to promise to license their patents under fair, reasonable, and non-discriminatory terms. And as we sit here in February of 2018, virtually all standard setting organizations worldwide have adopted some variant of these standard policies for requiring fair, reasonable, and non-discriminatory licensing. While the standard setting organizations have adopted fair, reasonable, and non-discriminatory licensing requiring participants to make that promise, they have not put any flesh on the bones as to what fair, reasonable, or non-discriminatory really means. So for a number of years after requiring these promises, market participants, both patentees and implementers, floundered a bit as to what was really meant by fair, reasonable, and non-discriminatory. The lack of common information among market participants led to a lot of litigation. But as regulatory agencies around the world, including those in the European Commission, the United States, China, Korea, Taiwan, and cases that have actually been litigated mostly in the United States, England, and recently in the Shenzhen Intermediate Court in China, began to address the question of what is FRAND licensing, we've come to coalesce around worldwide standards, and that will be the focus of today's discussion. The worldwide agencies, as well as courts, have now looked primarily at three ways to determine what is a fair and reasonable royalty rate for a patent that is essential to a standard and is subject to a FRAND commitment. And just by way of footnote, those FRAND commitments are now generally considered by courts around the world to be contractual commitments that a patent owner makes to a standard-setting organization of which an implementer is a third-party beneficiary. Thus, when a party participates in a standard-setting organization and agrees to abide by the FRAND requirement, it's making a promise to the standard-setting organization, but it's a promise that an implementer who is using the patent and technology to implement the standard can enforce through third-party beneficiary rules. So the agencies and the courts have coalesced around three ways to determine what constitutes a fair and reasonable royalty rate. They're not necessarily exclusive, but often used together to try to come up with what is a fair rate that an implementer should pay a patentee. Those three methods that I'll discuss in a little bit more detail in just a moment are the top-down approach, the licensing comparable approach, and the proportionality approach. They're easy to describe, but actually in their implementation, they're really quite difficult to come up with the variables that make up each of these ways of determining a fair and reasonable royalty. For the purposes of today's discussion, I'm going to generally talk at a high level about how you go about implementing these three methods of determining fair and reasonable royalty rates without, in the interest of time, necessarily getting into the details. So let me start with the top-down approach, which was recently employed both in a case in the United Kingdom involving Unwired Planet and a case in the United States involving Ericsson. It was also alluded to in a very recent case just last month in the Shenzhen Intermediate Court in a case involving Samsung. So the top-down method tries to address what is also referred to as the royalty stack problem. We know that while we may be addressing a question of just one patentee seeking a royalty from one implementer, but we do know that that one patentee is not the only party that owns patents that are essential to the standard. Just to use an example, and I'll be using the same example throughout today's discussion, that is the LTE or fourth generation mobile phone connectivity standard, which was generally set by ETSI and a few other standard setting organizations. There were almost 6,000 patents declared to ETSI under these FRAND licensing policies as being essential to the LTE standard that ultimately was adopted. There has been a lot of literature in the, both in the agencies and in the academic publications that people over-declare. And so the first task in looking at the royalty stack problem is to try to determine what are the true number of essential patents to any particular standard. Again, a complication that's probably beyond the scope of today's determination. But what the courts have done in applying the top-down approach is to reach some reasonable determination of the total royalty stack. That's the first variable. The second variable is what is the value of the entire technology to the product to be licensed. Not just the value of the implementer's technology, but the value of the entire standard to the technology. And finally, in order to come up with a top-down royalty rate, the third variable that you need to determine is the particular patentee's share of the royalty stack. So again, to use an LTE example and borrowing from some determinations that were made in the Unwired Planet case in London, The court there determined that there were approximately 1,500 truly essential patents for the LTE standard. You'll recall that that compares to the almost 6,000 that actually were voluntarily declared to ETSI in connection with its promulgation of the LTE standard. The court then determined that Unwired Planet, the plaintiff in the case, owned about 100 of the 1,500 truly essential patents. The court then also did an analysis of what's the value to a mobile phone of the LTE connectivity standard, determining that it was somewhere between 8 and 9% of the average selling price of the phone. Again, the ways in which those numbers were determined, the 1,500, the 100, and the 8 to 9%, is a complex matter that each variable itself deserves its own discussion. But in any event, those were the numbers that the court came up for the top-down approach. After that, it's just simply a question of math. What's the percentage of the plaintiff's ownership of the royalty stack? 1,500 total patents divided by 100 patents, or about 6.6%. Using an 8% value of the average selling price as a reasonable royalty, you multiply the 6.6% against the 8%, remembering that the 8% is the total value of all of the patents that are essential to the standard, and then you multiply that product, approximately 0.53%, against the value of the handset selling price. People use these days about $325 as a worldwide rate, leaving the plaintiff in the Unwired Planet case with a royalty for its total portfolio of standard essential patents to the LTE standard of $1.73. Two very interesting points about the top-down approach that don't necessarily apply to the other two that we'll briefly discuss. First of all, the top-down approach necessarily works on the basis of the entire portfolio of the patentee. Obviously, Unwired Planet didn't sue and could not sue on 100 patents, but the court nevertheless decided to set a royalty rate on the entire portfolio owned by Unwired Planet. Similarly, although the UK court would only have jurisdiction to enforce a UK patent, the Unwired Planet court decided to set a royalty rate for a worldwide license for the defendant in that case. A similar approach was used by the court in the United States in TCL and Ericsson. It remains to be seen, as both these cases go up on appeal, the extent to which the appellate courts will allow lower courts to set worldwide license rates on patents issued by other jurisdictions. But both the Unwired Planet case and the TCL case here in the United States operated on the basis of at least some measure of consensus and agreement by the parties in asking the court to exercise what may be a power beyond its typical jurisdiction. The second method that courts and agencies have used to determine fair and reasonable royalty rates for standard essential patents is the licensing comparable approach. Again, something easy to explain, but a little bit harder to actually implement. The licensing comparable approach asks the following question. Has the market developed licenses that one can use to determine that there has been a market acceptance of a consensual transaction in licensing negotiations? If the answer is yes, then a market consensus approach in a consensual transaction is typically used as the equivalent of what constitutes a fair and reasonable rate. The idea being that if multiple parties have agreed to a particular rate or a narrow range of rates, then that is a fair and reasonable rate if it's based on a consensual transaction. So the licensing comparable approach looks at what are the rates in comparable licenses for similar patents to similar technologies among similar parties. Once you figure that out, you have an accepted market rate, and that constitutes, under the case law and agency pronouncements, a fair and reasonable rate. The difficult question, though, is what constitutes comparable. Recent decisions have suggested that they use the word comparable broadly. So, for example, would a license to an LTE patent using the licensing comparable approach look at a license to a party such as Samsung the largest mobile phone manufacturer in the world, who may have additional bargaining leverage to negotiate a lower royalty rate in a consensual transaction, as well as including, for example, a license to a smaller player such as LG or TCL. Generally, the courts and agencies are moving toward using the word comparable to include all of those licenses, including big players, small players, and others, notwithstanding the fact that those licenses are entered into under a variety of different bargaining approaches and power. The third approach is far less quantitative and more qualitative. It is the proportionality approach, and it generally asks, what's the value to the patents at issue to the standard, and what is the value of the standard to the product? Both the licensing comparable approach and the proportionality approach, as distinct from the top-down approach, does not necessarily look at a patentee's entire worldwide portfolio, nor does it attempt to set a worldwide license rate. Either the proportionality approach or the licensing comparable approach can be determined wholly within the legal jurisdiction of a court to determine a fair and reasonable royalty rate only for the patents in suit issued by the jurisdiction in which the court sits, and only for the products being accused of infringement. The proportionality approach, again, easy to say but difficult to apply, asks, how can we determine the value of the patents to the technology and the value of the technology to the product at issue? One interesting aspect of the proportionality approach, as distinct from the top-down approach, is that it allows for distinctions among the quality of standard essential patents. In other words, not every standard essential patent is created equally. Some may relate to and bar the implementation of critical aspects of a particular portion of a standard, while others may not be nearly as central. The proportionality approach addresses that issue by looking at exactly what the patent claims and the value of that patent to the standard and the product at issue. So how do we determine exactly what is the value of a patent to a standard and the value of that standard to the product? Courts and parties in litigation have tried to use a variety of different approaches, none necessarily adopted by any consensus approach. People have sometimes tried to do this through technical experts who will testify about the nature of the patent claim and its value to the standard, and the critical nature of the patent to the benefit delivered by the implementation of the standard. Other litigants have done things like consumer surveys, asking, for example, a customer if the issue was a patent on a smartphone camera, what would you pay for this phone with a camera, and what would you pay for this phone without a camera, in an effort to try to get some indication of the value of the camera to the product, and therefore the value of the patent that reads on the camera. This is probably the least developed of the three methods to determine a fair and reasonable rate, and I'm sure we'll see more developments in this area as well as other aspects of fair and reasonable royalties in time to come. Let me now move to a second issue of significance to patent owners around the world and implementers of technology, and that's the extent to which patent owners can obtain through judicial process an injunction for a patent that is subject to a FRAND undertaking. You'll remember now that we're talking about patents for which patentees have promised to license their patents. So the question is, can you make that promise and still obtain an injunction, which obviously is quite the opposite of licensing the patent? Earlier on, many courts and commentators, as well as several agencies, came to the conclusion that once you had given a standard-setting organization a promise that you would license the patent under fair and reasonable terms, that you thereby gave up the right to seek an injunction. This, as well as many other developments in patent licensing, led to what became to be called efficient infringement. Basically, a patentee would face license negotiations where an implementer, even though recognizing that it was using patented technology, would decide to simply take its chances in a litigation. Would the patentee sue? If the patentee sues, could I prove a lack of infringement? Could I prove a lack of validity in the patent? If I lost on all that, my downside was probably not going to be far greater than what the patentee was seeking in terms of a royalty in the first place. As this led to increased litigation and lack of consensual licensing conclusions, regulators and courts came to the conclusion that perhaps barring FRAND-encumbered patents from seeking an injunction was not the best way to approach the marketplace. This is particularly true with the new head of the United States Department of Justice Antitrust Division, who has recently made several speeches in which he indicated that he thought that court determinations that you gave up the right to seek an injunction by making a FRAND promise were flatly wrong. Other agencies around the world are also coming to the view that you don't necessarily give up the right to seek an injunction if you have made a commitment to license your patent. Where do we seek the balance between enforcing the right to promise while also avoiding a user of the technology from simply not acting in good faith in license negotiations? The original determination of attempting to seek that balance came out of the European Court of Justice in a case involving Huawei and ZTE. That approach has become generally accepted in China, as well as it's beginning to be accepted in the United States. The approach tries to look at the good faith behavior of both patentee and implementer in license negotiations and comes to the conclusion that if the implementer has not acted in good faith, then the patentee may seek an injunction even on a standard essential patent that's subject to a FRAND declaration. The factors that the courts look at to determine whether a party has acted in good faith include, for example, has the patentee made an offer to license the patent that includes detail about how the royalty rate was computed, detail about how the alleged infringer infringes the patent. It then turns to the alleged infringer. Has the alleged infringer timely responded to the offer to license with as much of a detailed presentation to the patentee as the patentee made to the implementer? The courts then look at other factors after that, such as whether either party has offered to mediate or use some form of alternative dispute resolution to determine a royalty rate, or other factors that speak to the good faith negotiating process. And I think it's now reasonably clear that on a worldwide basis, a patentee can likely seek an injunction on a standard essential patent that is subject to a fair and reasonable licensing promise if the implementer has not engaged in good faith licensing negotiations. So that's the discussion for today. We are beginning to see the courts and the agencies worldwide coalesce on some very difficult issues that had been blocking consensual resolution of licenses. We now are beginning to see 3 ways to determine a fair and reasonable rate for standard essential patents that are subject to a FRAND declaration. And we are also coming to the conditions under which it becomes increasingly likely that the parties who are attempting to bargain about a license will know when an injunction can be considered. There are still multiple issues that need to be determined regarding the issue of what constitutes FRAND licensing, but hopefully this highlight review of the law around the world on these 2 issues will give us some better sense as to exactly what these terms mean. Thank you for listening today. For more information about this issue or our practice in general, please visit www.sullcrom.com. Thank you.